After Clause 12, Amendment 61, Baroness Chakrabarty.
My Lords, this group contains 2 amendments that seek to address dangerous practices relating to criminal evidence. Whilst this bill does much to protect victims of crime, our justice system must also protect people from becoming victims of miscarriages of justice. Both of the problems we identify have already led to serious wrongful convictions and risk many more in the future. Amendment 62, my Lords, I share with my noble friend and dear old friend, the Baroness Lawrence of Clarendon. So if honour by association was as easy as guilt by association, I would be honoured indeed. I ask members of the committee to consider whether they've ever indulged in crime procedurals as a guilty pleasure, whether reading them or watching them on their favourite streamer after a long night in committee in your lordship's house. I think Middle England is addicted to these dramas, whether on TV or in books. The creativity behind them is big business. But what if those who participated in the creation of that art, or even just enjoyed it, found themselves prosecuted on the basis that that interest was somehow probative of criminal intention or propensity? If noble lords find that a ridiculous proposition, they should spare a thought for the young black men and boys who have increasingly been prosecuted with reliance on their enjoyment of rap and drill music. Disgraceful, my lords. And this has been allowed to go on for some years now. Even more outrageous, there are groups and units of mostly middle-aged white police officers who hold themselves out as expert witnesses to translate this music and these lyrics and the patois for juries. And friends, learned friends at the bar, including my learned friend Keir Monteith Casey, who's currently in the chamber, have had to take this on in court and have dealt with miscarriages of justice in the Court of Appeal because of this kind of prejudicial and racially prejudiced practice. The figures are not good. The Crown Prosecution Service doesn't keep records of music evidence being used in this way in court, but studies in the University of Manchester in particular show that there have been many cases. We think 68 cases involving 252 defendants between 2020 and 23. Probably an underestimate because these are first instance trials, not always reported. 2/3 of the defendants in the Manchester study were black, 12% were mixed race, 82% were under 25 years old, 15% aged 17 or younger. Over half the cases were, of course, joint enterprise prosecutions, because there's a particularly toxic cocktail, my lords, when you combine the use of this prejudicial material with casting the net so wide in terms of joint enterprise. In the case of the Manchester 10, black teenagers were collectively sentenced to 131 years in prison for conspiracy to murder and to cause grievous bodily harm. During the trial, a 9-second video clip of someone identified as one of the defendants with drill music playing in the background was used as evidence of his gang membership. In closing, the prosecution told the jury that some of the defendants had become involved in gang culture, quote, because they had an interest in drill with its themes of violence, drugs, and criminality. The night manager, anyone? The Court of Appeal found that the young man had been misidentified and there wasn't even rapping in the video. This is how bad this practice is. He was of good character, head boy, captain of the rugby team, unconditional offer to study law. Forgive me being particularly attached to the study of law as a noble pursuit, but hopefully noble lords take my point. His conviction was quashed, but only after serving 3 years in prison. So, my lords, we talk about equality before the law. That requires that no one is above the law's reach, nor anyone below its protection. The shameful events currently rocking our politics only highlight the dangers of entitlement, hypocrisy, and the obvious destruction of trust in our vital institutions when there is, quote, one law for some and no fair hearing for others.
Hear, hear.
This is a modest but vital reform. It would create a presumption that creative expression, not just rap and drill music, but any creative expression on the part of a defendant should be inadmissible unless 4 tests are met. Firstly, the expression must have a literal rather than figurative or fictional meaning. Then it must refer to the specific facts of the case. Thirdly, it's relevant to an issue of dispute. And finally, that issue can't be decided by other evidence. In applying these common sense principles, our courts would have to consider factors including artistic conventions of the genre in question. Experts, my lords, should be truly independent. Further, in the rare cases where creative expression were admitted, the judge would give directions to the jury not to be influenced by stereotypes. Racial stereotypes are such a danger in this context. A lack of knowledge or understanding of rap lyrics and imagery will ignore the symbolism, storytelling and exaggeration that are key features of one of the UK's most widely consumed cultural forms. The misuse of the music in prosecution also risks suppressing the enjoyment and expression of the art in underprivileged communities that find it both creative and cathartic. My lords, every limb of our constitution needs to step up in the current moment. Yes, the executive and yes, the courts, but sometimes it is for Parliament, not least your Lordship's House and this committee, to step up when the other limbs have been derelict in their duty. I beg to move.
Amendment proposed after clause 12. Insert the new clause as printed on the Marshal's list.
My Lords, I also rise to support Amendment 61, to which I added my name. But before I do, I just want to associate myself with the noble lady's words on Amendment 62. And I was sitting here in the House and thinking, if I was guilty of the sum total of the creative expression that I have consumed, you would have to lock me up for life. So I really do think that it was actually quite moving to hear how one small fraction of the population is being discriminated against on this particular count. So I just wanted to add my support on that issue.
This is a much more difficult problem. And the problem has arisen because of the way in which drill music and similar music has been used in the prosecution of cases. And the admissibility of such evidence is quite complicated. Now, it seems to me that what is very worrying is the fact, as has been seen by the attendants here today of one of the counsel who've been involved in these cases, is that the way in which this evidence has been used in some cases has caused a lot of deep misunderstanding and a lot of suspicion about the way in which our criminal justice system operates for certain minorities. And the thought that you will be found guilty because of the music you listen to is deeply troubling. However, it does seem to me that what we need to do first is to look at the cases where this has been used. And I looked at the case of the Manchester 10, and coincidentally in that case, the evidence had been admitted by agreement, and the Court of Appeal upheld the way in which it had been used for certain purposes. It seems to me that this is a more complicated problem, and it would be helpful if the Minister was able to, between now and report, to be able to put before the House a short letter explaining what the problem is. And I think it would be easier to look at the amendment in the light of a better understanding. The last thing I want to do is to try and bore you all by explaining the way in which evidence can be used legitimately and can't be used legitimately. It's much better that you have the benefit of reading that on a piece of paper.
Excuse me, I rise in support of Amendment 62, tabled by the Noble Baroness Chakrabarty. Maybe I can help the Minister with some of the intricacies of this. We've heard from our noble and learned members here who have a legal background. I have a youth work background, and I'd like to say this. Much of the music that you'll be talking about, drill music, rap music, is horrific. The content of the music is horrific. It's horrible. But unfortunately, it's also very entertaining. And many, many young people will listen to it just by association. The music's entertaining, people party, you have no other choice. So for someone to view your output as an individual through your membership of that genre is a very, very slippery slope. Many years ago, I dealt with a group of young men who did make a video that did point to some serious criminality, and the police dealt with it in the right manner. They used it to understand who they might then have further investigation on. They didn't use the evidence, except one part of it was quite blatant, as a reason to prosecute particular individuals. And when someone tells you they're an expert in interpreting the music, I'm afraid they're wrong. I was born in that community, I come from that community. Many of my members of family make that music, but because young people make the music and technology allows them to make it so quickly, the words they use, the meanings they use, the characters they build change almost on a daily basis. If you were to say to my son, the man dem, he would understand, would you? When I grew up, the man dem as a concept existed, but the words didn't. So he and I can have a conversation about the same thing and not know that we're talking about the same thing. Very rarely will you hear me stand up and talk about race and accuse the police of being racist, but this cuts very close to that. Because when you have someone who's a lovely, well-meaning, educated, middle-class man or woman who listens to the music, they have no understanding of the cultural background of that music, or the fact that that music might have been produced in the way it was to display a character. Much of the bragging and the boasting is simply that, bragging and boasting about fictitious situations that they themselves hope they'll never be in, and we also hope they'll never be in. So to then present that in court as some kind of evidence of their associations and their behaviour, I think is a very, very slippery slope. And if you want to destroy the relationship between young people, and particularly young black people, and our system, this would be the way to go. So when I say we really do need to remove this as a thing the police do, I cannot express to you how important it will be, because you'll be making sure that almost an entire generation of young people cannot join our system, cannot become part of what it is to be British, just because of a cultural relationship they have, and in the mind of someone who doesn't understand them, have no way of disassociating themselves with. So with that bearing in mind, I really do believe this is something we should get behind and support. And again, if anybody doubts me, find a 16 or 15-year-old black boy and ask him to tell you about Parliament in the way he would speak to his friends. It will sound like a gunfight. Now, I don't know if you've ever been to Parliament. I've never witnessed a gunfight. The point I'm trying to make, young people live in a separate world. This music is another separate world again. We must be very careful about demonising and villainising them before we have any real evidence.
My lords,
I declare my interest as the anti-racism advisor to the Labour leadership. I share recommendation 62 with my noble friend Baroness Chakrabarty. I hope the noble lords might understand why I have done this, given my years of campaigning for the rise for race equality and in criminal justice system space in particular. Our amendment is essential, but also modest in preparation. Sorry, my language. We do not say that creative expression can never be admissible in criminal trials. We just say that there must be a strict rule that ensures that against racial prejudice in particular. It is not new in our system to try to ensure that the prejudice associated with criminal evidence should not outweigh the probate value. Nor, unfortunately, is it new to find that the police prosecution system working against people of colour when it should be protecting everyone from all our diverse community equally. As my noble friend has said, we wouldn't dream of prosecuting a middle-class, middle-aged white person for crimes on the basis of their writing or enjoyment of crime fiction. Sorry. Why then are we being happily prosecuting young black men and boys on the basis of rap and drill music? I think we all know why. We talk about equality before the law. About 28 years ago, Stephen inquiry, we would know the principle as principle is still not a reality. My noble friend had mentioned, Chakrabarty had mentioned a Mancunian young man, a model student, a head boy aspiring to be a law student with unconditional offer to study law at the University of Birmingham. That is until the police and the prosecutors wrongly mistook him for a youngster in a 9-second video in which drill music was playing in the background. In reliance on this ridiculous evidence, he was convicted of violence conspiracy. Conviction was overturned, but only after he served 3 years in prison. My lords, I urge the whole committee to support our amendment and my noble friends in the government to accept it.
On Amendment 62, I'm deliberately going fairly fast because I don't need to add a whole lot to what has already been said. There have been a number of occasions when I've heard a rapper and realised how very clever the work has been. I've really admired what we've heard. And then I thought back to the occasion decades ago when my father started criticising my musical taste and calling it Simon and God Awful. But tastes change, generations move on and develop. And I can't speak to the detailed content of all rap and drill, but I think we're in danger of dismissing the importance of this music to the generation that produces it.
Yeah.
Sorry. My lords, I'm grateful to the noble Baroness Lady Chakrabarty and her eminent supporters for bringing forward these amendments and for the contributions of all noble lords in respect of Amendment 61 and indeed Amendment 62. As to Amendment 62, this proposes a new clause to prevent an over-reliance on a person's musical taste as probative of criminal proclivity or intent. We agree on this side that a person's creative or artistic taste should not result in them being treated prejudicially by the judicial system. And we've heard from Lord Bailey of Paddington and from Baroness Lawrence of Clarendon in support of this amendment, as well as Baroness Chakrabarty and indeed others. We do have some reservations about this amendment as it's currently drafted. We accept the good intentions behind it. We understand the danger which it is designed to meet, namely that people are treated prejudicially for their creative and artistic tastes, and it's undoubtedly the case that those from particular backgrounds are vulnerable to this and may suffer or risk suffering mistreatment, in effect, in our courts. Against that, we fear also that the amendment might create other difficulties, creating genre-specific shields for certain evidence and thereby treating some expressions differently from others. In other words, shifting the balance too far and creating another class which is not protected. My Lord, we suggest that while we are sympathetic to this amendment, for those reasons we cannot support it.
My Lords, I get to my feet with some diffidence given the range of speakers, eminent speakers, and many of whom I have the most utmost respect for, who have spoken in favour of this group of amendments. May I now turn to Amendment 62, again in the name of my noble friend Baroness Chakrabarty and of my noble friend Baroness Lawrence. I am very aware of these issues, particularly in relation to rap and drill. I have, before I knew about this amendment, but in the course of my practice and when I was a judge, been to a number of lectures on the subject and read a number of articles, including some by Keir Monteith, King's Counsel, who I see is sitting below the bar this evening. Well, the question here, in terms of the use of this material, is one of relevance. And like the noble and learned Lord Thomas, I don't really want to go into a boring exegesis of when evidence is admissible and when it isn't. But I think the real concern here is to make sure that if, and it's a big if, this evidence is to be used, it has proper probative value on a basis that it goes further than either this defendant is a bad person because they like rap and drill music, or even worse, some spurious and crude racial stereotypes. My Lords, judges, of course, have a duty to ensure that only evidence meeting these standards is adduced, and they should exclude any evidence that doesn't meet the required threshold. It's not a matter of discretion, but I do understand the concerns about the fact that this has not happened in all cases. My Lords, it's axiomatic to say that creative and artistic expression is of itself not a crime, and it's very rare that it would feature in the evidence of a prosecution unless it inherently involved criminal activity, like damaging another person's property with graffiti or drawing sexual images of children. As to musical expression, the Crown Prosecution Service are clear that creating or listening to music is not a crime, but they would say that on occasion they have encountered cases where, upon investigation into a violent offence, it became clear that drill and rap music had been used in the build-up to encourage or incite violence or reveal information about a crime that only the attackers would know. These instances are rare and, importantly, are already subject to rigorous scrutiny under existing evidential rules. But I am aware of the disquiet, and we do understand the community concerns. And I do take the point made by my noble friend Baroness Lawrence. I'm a lover of crime fiction, but I don't think anybody is ever going to use that in a prosecution, I hope they're not going to, in a prosecution against me, and she makes a very valid point. So the Crown Prosecution Service is actively consulting on this matter through a public consultation, seeking views on whether formal prosecution guidance should be issued regarding the use of musical expression evidence. We want to ensure that any future approach is clear and informed by a wide range of perspectives. It's government's view that, as currently drafted, the amendment would be unduly restrictive and effectively frustrate the ability of the Crown to adduce relevant and probative evidence before the court, with potential consequences of frustrating justice for victims in some serious cases. The government intends to await the outcome of the CPS consultation and announce next steps in due course. So I invite all noble lords to withdraw their amendments.
Before the noble lady sits down, I didn't speak to Amendment 62 when I briefly got up, but in doing some research for it, I think it is usually the case in a particular area of law where you have a body of experts in particular areas of evidence. It is not uncommon for those experts to be used by both the prosecution and by the defence. Okay, in doing my research on Amendment 62, that is not the case. The so-called experts who are used by the prosecution are solely used by the prosecution. The experts that are used by the defence, who are experts who would be able to talk knowledgeably of the sort of detail that Lord Bailey was able to give us, are only used by the defence. That in itself, I think, tells you something, that there is something wrong.
I don't disagree with the noble lord. I think I've already made it clear that I understand the disquiet and I understand the concerns about that disquiet and the very real possibility for something that is, in fact, crude racial stereotyping to look as though it's evidence, and that's why we need to await the outcome of the CPS's consultation.
I'm grateful to all noble lords who spoke in what I think was a very important debate that did credit to the whole committee. I'm most grateful of all to my noble friend, the Minister, who is a distinguished criminal lawyer and a distinguished former member of the CPS. But with all due respect, no one should mark their own homework. It is not even for the Crown Prosecution Service to mark its own homework, nor any other lawyers even to mark their own homework. So I do, in relation to Amendment 62, to go in reverse order, urge my noble friend to consider what Lord Russell of Liverpool and others have said about what is happening in practice, the University of Manchester study, so on and so forth. Because just reading out the official statement from the CPS is hope sapping, and I know that my noble friend would not want to sap my hope in difficult times. And I think in relation to 62 and 61, she suggested that she is listening, and said it with some personal input. She is not an AI. She is not a, she is not a projection from the government. She'll forgive me saying so. She's one of our best advocates on these benches. The government is very, very lucky to have her. But as I know our noble friend Lord Timpson has said publicly and privately many times, we're not all here forever. We're not on this earth forever. We're not in this chamber forever. We're not in positions of power and influence forever. We must make the most of our opportunities to make change as was promised, and to make it for good. And race equality surely must be one of the foundations of any Labour government, specifically one that has promised so much. In relation to 61, I think the case once more was incontrovertible. By the way, in relation to both amendments, I heard no proper pushback from any side of the committee. On 61, I have to defer to the noble Lords Beamish and Arbuthnot of Edram, and to the noble Baroness Kidron. The time is now. The vehicle is this bill. And I would just finally say gently to my noble friend, when she walks into rooms in the Ministry of Justice with officials or even Commons ministers, I hope she realises that she's the cleverest person in the room, or at least the one with the most direct experience of practising criminal law in the courts. And if anyone can find a way through, I trust that that is my noble friend. and I urge her on 61 and 62 could theoretically be dealt with by rules of court, but it must be dealt with. I think that with 61, we need an urgent legislative amendment in this bill. And she foreshadowed the possibility of a way through, partly on her concerns about sole and determinative evidence and partly responding to the noble Lord Russell of Liverpool. I urge her to deliver for the committee, to deliver for the people of this country, yes, for the past victims of miscarriages and for all those who might come. So I say that as respectfully and positively as I can to my noble friend. I hope she knows how much respect I have for her. But we are looking for something at report in both respect for 61 and 62. But in the meantime, I beg leave to withdraw.
Yeah. Is it your Lordship's pleasure that this amendment be withdrawn? It is by leave withdrawn. Amendment 62, Baroness Chakrabarty, not moved.